Hey, ma'am. This is Officer Benjamin again. He stated that he fired his public defender and then he.
I was gonna let the judge know that he would like to represent himself.
Okay. Would you want me to get him back here so that way he can?
Yeah,
Okay,
I think he
easy
needs
enough.
to talk to the judge. Yeah.
Okay, easy enough. He will be coming back right now.
Thank you.
All right. Just stand by. Sorry about the.
This one's Alyssa's fault. The next one, I believe, is Anita's shot. Let me confirm that.
Confusion.
No worries.
So, it's actually.
He's back now.
So this is Mr. Richmond, Judge, and he is elected to represent himself this morning.
Yeah, she can't represent me.
She's
not
That's
my
fine.
lawyer. I
I
fired her
just let
last
the
year.
judge know.
Hold on one second. Let me call the cases up. 24 GE 5316 24 TO 712. City of Boulder versus Nathan Joseph Richmond. Are you Mr. Richmond?
Yes, sir.
Morning, sir. And go ahead, Mr. Altenberg, enter an appearance, and Mr.
Yes,
go ahead, enter appearances.
Yes, Your Honor. Michael Altenberg for the people, bar number 60964.
Thank you. Mr.
And Ashley Talene, number 46200. I am not representing Mr. Richmond this morning. He is electing to represent himself.
Thank you. Mr. Richmond, is that true? You wish to proceed without counsel?
No, I'd like a lawyer that's competent, actually.
All right. Do you have any specific concerns about Ms. Talene's competency?
Yeah.
Okay. What we need to do at this point is, Mr. Altenberg, I need to conduct a brief hearing outside the presence of the prosecution.
Okay. Would you like me to leave the call or join the breakout room alone?
Just join the breakout room alone.
Yep.
All right. This is a hearing. I'm trying to remember the case. I've conducted these before, but the hearing really is for purposes of me to determine whether to remove counsel, appoint a different counsel, or allow you to proceed pro se, sir. You indicated that you had some concerns about Ms. Talene's competency. Please expand on that for me.
She won't even give me the time to explain myself and formulate a reasonable defense. And furthermore, when I asked her to take a picture of evidence at the courthouse, when I was not allowed, she refused. She walked right past it. That's not cool.
Have you been able to have meaningful discussions with her about your case?
No, I told her I needed to meet in person outside of the courthouse, and this was not accommodated for under any reasonable situation.
Judge, I will let you know at that time I was actually not representing Mr. Richmond because at that time he was out of custody and I had not been appointed on his case. And then I was going into the courthouse when this happened for a different case in district court for a client that I was actually appointed on.
Well, he's asking, I think I have a lot of discretion in a situation like this. He's asking that I appoint another lawyer. Do you have a position on that request? I don't think I need to find whether there's a competent counsel or not. I think if there's a communication issue between the two of you, I think I can simply have you removed and then appoint somebody else. But I am not making a finding of incompetency because that's not consistent with my history with you.
Don't worry, this guy gets even dumber.
Go ahead, ma'am.
I do think we are having a communication issue at this point, so I wouldn't object to the court appointing different counsel for that reason.
Mr. Richmond, did you wish to say anything else? I mean, I've kind of indicated what direction I think I'm going. Do you have any?
The priorities are clear, sir.
Say again?
And I am not a priority for Ashley. That is my stance.
All right, I understand. Okay. Yeah, I've actually done private work in the past, and sometimes things work out and sometimes they just don't. And then this is one of those
We just simply
situations.
don't see eye to eye on our interpretation of the Constitution. I think it's plain as day, black and white. She sees gray.
Okay, all right. You're released with thanks to the court, ma'am. Thank you. Okay, now Fernanda, let's bring we can bring the city attorney back on. I need to arrange to have a lawyer appointed for you. I just need to see how I can do that. I'm not the usual judge. Judge Khan is and I'm just filling in for the morning. So
Can I make
May I
a
ask you a question, sir?
Judge Khan, I think Lau put Judge Khan on leave. Okay, I'm just making that up, but it's possible.
Can I make a recommendation real quick, Judge?
Go ahead.
So both of these charges require the court to give him PR bonds.
Okay.
So I would suggest giving him PR bonds and setting a new court date and then having his new attorney appear at that date.
I guess that would work. Mr. Altenberg, do you wish to be heard on that?
Yes, Your Honor. It is my understanding as well that both these charges in question do require PR bonds.
And Mr. Richmond, did you have any concerns about proceeding in that fashion?
No, sir. I am due a PR bond as according to the law in my interpretation. Absolutely.
Well, it seems everyone agrees with you as well. So I'll go ahead and convert any bonds in these two cases to personal recognizance bonds. Fernanda, looks like we need a court date and we'll need a lawyer available on that court date for Mr. Richmond.
Sounds good, Judge. Can we so he has two cases. One is a traffic matter and the other one is a general. If we could reschedule the traffic for this coming up Wednesday, and then let me just double check on the general docket to see when we have a.
It'd be better if can we join them together so that counsel can appear once instead of appearing twice? Is that possible?
I'll leave that question for the city attorney.
Your Honor, I'd first like to state for the record, it's my understanding that due to next week's holiday schedule, the traffic docket has been moved to Monday and not Wednesday. I do not believe there's currently a scheduled traffic docket this upcoming Wednesday, the 2nd. With that being said, to have both cases addressed at the same time for efficiency purposes, that is that we have no objection to have that be done.
Okay. Let's see if we can get that hammered out here.
We could, I'm sorry, Michael, can we do on Tuesday or Wednesday? Sorry.
To get them both addressed at the same time?
Yes.
The Tuesday docket, I believe, can be done without any issue. We do have the general arraignment docket that date. And having the traffic case also addressed at that time, there should not be any issues with that.
Of course. Judge, just correct me if I'm wrong, but at this point, since the defendant is going to be no longer in jail, he would have to.
I'm going to appoint counsel for him, and he can come in and fill out an application.
Sounds good. So I can provide the application on Tuesday, and then we can give one more continuance after that.
Okay. All right.
Thank you.
Thank you. So Tuesday at what time?
8:30 in the morning.
All right, Mr. Richmond, Tuesday at 8:30 in the morning. You come in and fill out an application for court-appointed counsel, and Judge Khan, I'm sure, will be happy to review that.
Now wait for it.
Do you have any questions, sir?
Are skateboards allowed in the courthouse or not?
Gosh, I don't know. I don't know.
It's my
I probably
understanding.
wouldn't bring it in.
I do know from personal knowledge that there is a specifically oriented skateboard and scooter rack immediately in front of the courthouse.
That is my concern, sir. You can't reasonably lock up a skateboard, as I pointed out in December, which led to some of these problems. with the county, I believe, not the state technically.
Free the skateboards.
Well, I have to say, Mr. Richmond, I've been doing this for about 19 years. Nobody's ever asked me that question. That's why I don't know the answer
You know why nobody's asking that question? Because it's stupid. Really stupid.
to it.
Yeah,
Not interested in causing additional problems for you, but maybe
that is my mode of transit. So
You need to be mocked publicly. I am mocking you publicly as a public service. I expect a medal for this. I deserve one. You asking a judge if you can bring your skateboard to court should be punished at least with a thorough mocking.
it does directly affect me, and I understand it is
well,
a
you
rare
can walk
thing.
as well. I walk to places too. So if it's going to create additional problems for you, we always
There is such thing as a stupid question, and you just asked one.
got our feet as an alternative. We'll see you on Tuesday morning.
Are you requesting that I not bring a skateboard, sir?
I don't care whether you ride a skateboard or not, but if they're not permitted in the courthouse, you're not going to bring it in the courthouse. And if that's going to present problems for you and somebody's going to steal it, I mean, you're going to have to brainstorm.
Precisely, sir.
have to
By
brainstorm.
employing that rule, you're opening me up to clear and easy theft.
Clear and easy. I'm sorry.
You're opening me up to very easy theft, as you can't reasonably lock up a skateboard like you can a bike.
With theft. I see. I don't, you'll have to problem solve it.
Yeah, I mean, I'm a
You have to-
homeless man, and you got
Yeah, that sucks for you. I love the way the judge handles this. I honestly do. I love the way he handles this and the next dumb question. I give him a lot of credit. I don't care. You know, we don't have accommodations for this because it's a dumb method of transportation for going to court. That's why. If you choose that, then you work out the logistics. It's not the judge's problem.
are
Like I
opening
said,
me into theft. Just
I'd like to drive to court in a Rolls Royce. I don't get to do that. So if you're not going to skateboard, maybe you can just walk on your feet here. Look forward to seeing you.
I
on
presume
Tuesday
you won't
morning.
mind me camping on the premises then.
You have a good day. I'll see you Tuesday. Thank you.
Have a good day.
You as well.
Yep, see you next Tuesday. First of all, the judge tells him to walk, which is cool. And then he says, well, I hope you don't mind me camping in the courthouse. And he's just like, I'm not, I've responded to one dumb question. It's over. It's over. Go camp on the courthouse lawn if you want to. I don't know where we are. Are we in Washington? They'll probably allow it. Any place else, you'll be arrested for it. But whatever, it's not my problem.
Marshall,
I
thank you. Marshall, thank you for your help.
Other stuff.
Is there anything the state wants to, defense wants to present?
Not regarding this.
All right, summarize.
That's right. It was Colorado because he's stepping in for Khan. I don't know if they'll arrest him or not. We shall see. All right, this one is interesting. It's Anita Shah to send it to me, and it was really long. It was about an hour and 20 minutes, and I cut out the actual preliminary hearing. Suffice it to say, they called a couple of witnesses, and the point where I said I'm going to cut this off is when they got into a serious intellectual discussion, mostly Judge Stevens, talking about the difference between present sense impression and an excited utterance. These are two exceptions to hearsay. I mean, I wasn't going to subject you to it. You would have learned something that you will never use. So I just cut that whole bit out, and we go right to the end here, closing arguments on that so you can hear what happened, and then we get into the roll.
The state may go first and close.
Judge, I'll remind the court the call out for this original case. Let me ask Judge, do you have a copy of the PSI?
No, not with me right now. No, we don't keep those here in these files.
You'll note from the original PSI that led to the items that Father was on probation for is that 2 officers were called out for domestic disturbance. he was in an apartment and basically was refusing to let them come in. They had heard evidence of some form of violence going in, so they had reason to gain entry to determine safety of the individual. And the result is that that particular lady was assaulted. She would not move forward with charges. The offenses that he was placed on probation for was the struggle that ensued between Mr. Connor and the officers there that never should have taken place in the first scenario. That I point that out because that's the nature of what we're dealing with here. We've got a lady who is in a relationship with Mr. Connor. There's accusations about other time frames of assault, but specifically as to this instance on April 13th, we've got two different officers who observed fresh injuries that are in State's Exhibits 1 through 4 that fit with what they were told. And the limited exceptions that we've got is that statements that were introduced is that Mr. Connor, who is in a dating relationship with Miss Victoria, caused those injuries. That's the nature of the lesser included offense of family assault that I told the court I would attempt to prove today. I believe that all the elements of those are there for the court to consider in a scenario for ponderance.
Now you're speaking
evidence.
about assault.
Family.
Under section 22.01, the
Yes, sir.
lesser included offense,
Yes, sir.
which defines assault as being a person committing an offense
Don't worry, this gets a lot worse. It just takes a minute.
if that person intentionally, knowingly, or recklessly causes bodily injury to another, including the person's spouse.
Correct.
All right. And
So I'm asking for a finding of true as to that lesser included offense as to count 1 in combination with the remainder of those counts. Once the court enters its ruling on that, I'll have an opinion about the resolution.
okay. Defense?
Yes, Your Honor. Regarding the allegations, and I'm going to take them separately here, the ones that were discussed at the first hearing, he pled true to those. Okay. So those are issues here where we're asking the court to give him mercy. One of them is the money he couldn't ought to pay. He paid what he could, so I don't think that's an issue for the court. As far as the anger management goes, it's something that he still had time to do, and we would suggest the court, if the court continues on probation, he can get that taken care of. As far as I think the big one here on these is the being out past his curfew, because we know that he was out past his curfew because that's when this alleged incident happened, and he even admitted that they were there. He mentioned that his car had broken down, that they were stuck there, and it wasn't intentional trying to be out past his curfew. Okay. I think based on those, the court should have some kind of mercy on him and some kind of administrative sanction or something like that, and continue him on probation. Now, the big one we have here is the new offense. This is the one we were talking with today. I would argue that the state has not met their burden to prove up that this happened, in the sense that the victim was not here to testify. One of the things is in an assault is I don't want to say consent, that's not the right word, but that may be what I need to say, is that if he did do what they're alleging he did, it's without the effective consent of the victim. Okay. And we don't know that. Okay. That's the problem here, is the victim's not here to testify what happened, what was going on, more of the details. All we have is what the officers were told that night and what they saw. Okay. And that's what I asked the officer about. And he's doing his job, doing a good job of just reporting what he saw that day, what he was told that day. But we don't know what was going on because the victim, the alleged victim, is not here to testify. Sometimes assaults are not assaults because there is consent. And I don't know if this is a situation where it was. We just don't know. That's the thing. For example, if
That would be an affirmative defense, right?
yes, but there's nobody.
You could have called the lady.
Well, she doesn't want to cooperate. That's the
I
thing
don't
here.
care.
That's what I'm saying.
It's not for me to
Yeah.
decide. I mean,
She
but
has
there are
not.
there are methods of bringing someone forward. if it's important enough, that wasn't done in this case.
Well, they still have to prove all the elements, and that's what I'm saying. Is,
But you're saying you're stating an affirmative defense. That's not for them to.
I don't think it's. I'm not sure it's a affirmative defense, Your Honor. They still have to prove all the elements of the case.
No, once again, it's intentionally, knowingly, or recklessly causing bodily injury.
Right.
Consent isn't in those elements. Or
Yes,
lack of consent is not in that.
Right. Okay.
So that's not.
But still, the point is, Your Honor, the victim, they did not have anyone here testify regarding that. All they had was the officers testifying what was made available to them. And like I said, the officers doing their job. I'm not saying anything negative about the officers, of course. They were just reporting back to the court or testifying to the court what they were told. And I don't believe that that's enough to establish that he committed an offensive assault. Okay. So I would ask the court to make this ruling on the offense or the allegations that he pled true to, and we're not denying or defending those, and set his punishment accordingly to those and not to this alleged new offense.
No, I don't think it's necessary, Jeff.
Okay. All right. There is no debate on allegations 4 and 6. I'm sorry, 2, 3, 4, and 6 of the motions to revoke probation, as in each of those allegations, the defendant pleaded true earlier, voluntarily, knowingly and diligently to those actions, understanding and appreciating that a voluntary and knowingly plea of true to one or more violations of probation would be enough under law to grant the motions to revoke probation. Probation can be revoked, they can be found guilty and be sentenced up to the full range of punishment. So the court finds those allegations to be true based upon the affirmative representations, the voluntary statements made by the defendant in that earlier hearing we held in this case on June 16th, 2025. Allegation number 1, committing the offense of continuous violence against the family, and then what that deals with is dealt with under section 25E.11 of the Texas Penal Code. And
Oh, I thought that I lost
it
the
states
time
that a
again.
person commits an offense if during a period that is 12 months or less in duration, the person 2 or more times engages in conduct that constitutes an offense under, among other things, section 22.01, subpart A, subpart 1 of the Penal Code against another person. The state admits that there isn't that element of continuous violence under assault is not proven. Section 22.01A1 is assault, and it is included in the elements of continuous violence as alleged for the violation. Thus, under law, it can be considered as a lesser included offense that could be used to subject the defendant to revocation of probation. And it states that a person commits an offense if the person intentionally, knowingly, or recklessly causes bodily injury to another, including the person's spouse. The court finds that the state has proven through evidence that the defendant did commit the offense of assault by intentionally, knowingly, or recklessly causing bodily injury. And it is also within the penal code definitions bodily injury under section 1.07 definitions under penal code states bodily injury means physical pain, illness, or any impairment of physical condition. The testimony and the evidence presented shows enough that the victim in this case was exhibiting wounds or injuries from a recent occurring assault, and that together supports the conclusion that the defendant is in violation of his probation by committing the offense of assault on or about April 13th, 2025 in Jefferson County, Texas. Thus, the court finds number one to be proven true through the evidence presented today, and thus sufficient evidence is in the record to support these motions, first amended motions to revoke unadjudicated probation, and defendant's probation can be revoked. What do the parties say about what should be done next? State.
Yeah, I would re-tender in the PSR that for your education, the defense is going to be asking for a second opportunity for this defendant. And honestly, he's already had that. 2015, he was given a chance at probation, which he failed at. That was resulted in giving him a 4-year sentence. Really, the state gave him either his second or third opportunity whenever we gave him this probation that was deferred in 2024. And so what we're dealing with here is 9 months later, he's still committing assaultive type behavior. And he has no compunction about it, doing it. He's out at 2:30 in the morning, when if he had any intentions of following your probation, this man would not have been there, would not have been in the circumstances, and would have been walking the pine narrow to try to prove his character. Instead, we have the opposite. I would recommend for the protection of those here in Jefferson County that he loves to pray upon. I speak for the women that have been his victims in the past and ask that he get 8 years.
You're asking for 8 years in prison?
Yes, sir.
Go ahead.
Your Honor, Mr. Hannon is right. I am going to be asking to continue my probation regarding the allegations that he pled true to. Those are things that he can correct and fix and carry on, get his community service done, catch up on his money, do his anger management. As far as being out past time, that was a big mistake, and I would ask the court to. The court wants to give him some kind of administrative sanction, for example, some jail time as part of his probation, and continue on probation. He's on deferred probation, or another alternative the court has, as the court's very aware of, revoke his deferred probation and put him on regular probation and let him continue to catch up and do the things the court initially told him to do that he just hasn't got to yet. Anger management, community service, things like that, and catch up on his fees and fines. So we would request either to sanction him with some jail time and continue on probation, or to move it from deferred probation to regular probation.
Do you want to say anything, Mr. Connor? This is your opportunity to speak, but make sure that you run whatever it is you want to think about doing by your attorney. Okay.
First of all, Judge, I want to say,
Stand up, please. Thank you, sir. Go ahead.
Stevens, to my lawyer and VA.
as well as my probation officer. I want to apologize to you guys for the, you know, for the messing up on my probation, not reporting the stuff like the things that I did wrong. And I want to say that all those things about the young lady is not true. She was in a fight earlier prior that day, and that's why she was mad at me because I kicked her out of my house because I didn't want to get evicted because I had just got this apartment and I wasn't trying to lose it because I didn't have nowhere else to go. My mama left the apartment to me, so and I've been having problems with this girl, but I love her, so I try to give her another chance but she's I'm getting to the point where she's not bringing me no good, she's only bringing me bad. And even like right now, I'm going through situations that I shouldn't even be going through because of her.
I'm sorry. No. You're going through the situations you're going through because you bit police officers, and committed assaults on peace officers. That's why you're here in the first place.
Okay.
Don't forget, let's keep your eye on the ball. You shouldn't even be on probation. But no, you decided to commit aggravated assaults on peace officers.
So I said,
You pleaded guilty to those.
I did.
All right, you want to take those back? You were under oath. You want to try perjury as well?
No, I'm not talking.
You looked me right in the eye and said, I did this. I want you to put me on probation. Do you remember that? Do you remember that? All right. That's why you were here, sir.
Okay. But that's not what I'm talking about, Judge Stephen.
I know you wouldn't want to talk about that, but it's assaultive behavior. And this alleges another assault.
Okay, Stephen.
I told you got better. It's delicious. This goes on for a while.
But to be honest with you, Judge Stevens,
Yeah, that would be nice. Be honest with me.
I didn't even assault those police officers, and I have proof of that. But I had a lawyer.
I want the state to consider filing a perjury charges for this man. He is making statements to this court, and you pleaded guilty voluntarily, knowingly, intelligently, under oath, saying I committed, and you're going to interrupt the court, Mr. Interrupter. You pleaded guilty under oath, and you're now looking me in the eye and saying you didn't commit those crimes? That's perjury.
I didn't even know that was perjury.
Oh, you just think lying is just normal?
No, I just don't know the law.
It has consequences.
Nobody never taught me the law.
Yes, well, sir, we went over this real thoroughly.
And I did.
Hold on.
I do.
Hold on. We're going to refresh your memory. This is important.
Yeah, this is not going well. Stevens is having none of this. None of it.
I need the affidavit, the plea paper on the entry of the plea on in either one of those. It's going to be the same one.
Can I finish?
Stand by.
Yes, sir.
Oh, Leon,
Yes.
you're going to be towards the back onto the right hand side. Not all the way back. I'll reprint them.
Yeah. Sometimes they don't put those in. It's in there. They're in the record because they have to be in the record.
And it should be done.
I just. What this court does not tolerate or false statements, because we've got to work on accuracy. Now, this court knows that people don't tell the truth from time to time. And
You have a very hard one. You know? Okay, I don't know. I don't even, don't even show. I don't work. I don't have no record.
hey, sir,
There's
be quiet. Thank you.
And
Shut your hole.
What makes this court angry is that we really can't resolve matters when people can't tell the truth. And we know that happens. When they don't tell the truth, they get called on in this court.
I apologize, Jules, once again. I didn't mean to not say you.
Well, maybe you just don't understand what perjury is, but it's lying under oath. Here's a statement you signed.
Yes.
This is your signature. There you are, right there. See your signature?
Yes.
You can see it. All right. See this yellow part? All right. This is sworn under oath. This is what we do in every case when people enter pleas of guilty and when they want to enter a plea of guilty. And this is duplicated in each case. And this is charging you with assaults on a peace officer that you were placed on probation for. I have read the charging instrument, the indictment, and my attorney has explained I committed each and every element alleged, which means you are admitting to assaulting the peace officers that a few moments ago you said I didn't do. I am guilty of the offense and all lesser included offenses charged against me in this case. Listen to this, Paul. This is really the catch. I swear that all of the following, as well as the testimony I give, is the truth. So help me God. So
I know.
you
I didn't read it.
you interrupted once again. Let me make the point. You admitted under oath you were guilty. You swore to God it was guilty. And then you have the audacity here in this proceeding to say, I didn't commit those crimes. You just admitted or made a statement that is completely contradictory to what you swore to under oath. That's what we call perjury. Now, you want to take it back?
Yes, sir.
See, the problem is that you lose all credibility when you get caught lying under oath. And that's what we're trying to figure out, is what the truth is.
The truth is,
I just wanted to stay out of his way because it's so good. But Judge Stevens, and I think this is good. I don't mean this mockingly. Judge Stevens seriously sees himself. He's like, I am the humble servant of God, the United States, and the people of the state of Texas. And you sit in this courtroom and lie to me, you're lying to all them. Hell no.
I was never talking about those. That.
Oh, we're going to believe you now?
But I was trying to tell you about a situation that I was having with this girl. But anyways, the thing about it is, the Stevens, I truly apologize for everything that I've done. You know, all the wrong ways. I mean, I try not to do wrong. I try to do the right thing.
It's somebody else's fault.
It's never no right.
Is it your fault?
It's always my fault, Judge Stevens.
It's always your fault? I'm talking about just this. I'm not saying asking you to take the blames for all the sins of the world. I'm talking about this case, this hearing, these allegations. Are you accepting responsibility for
I'm
it?
not accepting responsibility for those. No.
Okay.
As far as assaults for the police officers, yes, I accept the responsibility.
Oh, that's not what you said a little while ago, was it?
Probation. But Judge Stevens, I mean, come on. I mean, life has been kicking me in the butt, man. I mean, I just,
Sir?
I said, like my life, things just hasn't been going very well.
Sir, life is what we make of it.
And I understand.
And everybody makes choices. Everybody makes mistakes. It's how you deal with your mistakes.
Yes, sir.
You have made serious mistakes that you have not dealt with responsibly. And at this point, the way you respond to it is defiance. By getting caught in a lie here, I didn't even assault those officers, even though you admitted under oath you did. That's what's important. We don't take these allegations lightly. This is serious. We have to rely on the evidence. We have to rely on sworn testimony. We have to rely on the truthfulness to get to the bottom, and that's what this court has to do. This lady is injured, and it's clear that you were found responsible according to the investigation, and this court finds from the evidence presented that it meets the definition of assault. But you were on probation for assaulting two peace officers. You have no business assaulting another person, much less someone. Your relationship with this lady was what? Were y'all married or?
We was planning on being married.
Okay. You were in love with her.
But just think,
Wait. You were in love with her, right?
yeah, I was in love with
Okay. This is, if you are going to assault peace officers who are doing their job, if you are going to be assaulting someone who you claim you love, what would you do to somebody that you didn't like?
I think it was something. Look, just she got in the fight. She was mad. She was mad because I was kicking her out of my house. I'm telling you.
Somebody else's fault, isn't it? It's somebody else's fault. Just like I didn't really bite those officers. It's somebody else's fault. Sir, I learned when I was young, you make mistakes and you're going to be held accountable when you make the mistakes. So you try not to make mistakes. And you certainly don't want to get caught in a lie when you were under oath, when you said a different statement. You, sir, just have a problem being truthful. You have a problem dealing with other people responsibly. The way you deal with issues is to assault. You use violence. No, sir, you have a rich history of doing that. You were pleaded guilty to two assaults. You pleaded guilty under oath that you tried to lie about a little while ago. Then this court has found sufficient evidence that you committed assault while on probation for assault. You are going to be held accountable. It's something you don't like, being held accountable for your mistakes, but we all are. We all are. And is there anything else you want to add?
I just want to say, Judge Steve, first of all, listen, please listen. I mean, you saying about the type of way it was when I never had my father, and I didn't have nobody to help raise me and stuff like that. But that's
it's
what I'm trying to say.
Life's fault.
I never assaulted that girl.
Yeah. Let me ask you this.
And that's
How many misdemeanor convictions do you have?
Probably about 2.
This is more fun.
Sir?
I don't know. Probably about 2 or 3.
Wait, this is your life. This is your life. Nobody knows better than you. You don't know how many misdemeanor convictions you have had?
Probably had about 2 or 3 of them. I don't know.
All right. Let's see. It starts off in 2009, illegal possession of marijuana. You were put on probation and then that was revoked. Criminal trespass in 2010, 30 days in jail for that. Illegal possession of marijuana in 2010, 30 days in jail for that. 2014, failure to identify, 30 days in jail for that. 2014, evading arrest and detention, 30 days in jail for that. 2014, resisting arrest, 30 days in jail for that. 2016, failure to identify, 150 days in jail for that. 7. Resisting arrest and search in 2024, 120 days in jail for that. And assault causing bodily injury to a family member in 2020, 60 days in jail for that. What do we have? 9. You said 2? You know more about your life. You got 9 misdemeanor convictions. Plus, how many felony convictions do you have? evading arrest or detention with a motor vehicle that you were on probation for in 2015, and that was revoked in 2018 because you couldn't stay on probation properly, and you were convicted of that. And that makes you a felon, which means you can't even get probation by a jury on anything. And now we have 2 more assaults of peace officers. You're looking me in the eye and trying to sell me with, I've only got 2 convictions, and these are 10 plus 11, 12.
I'm just trying to look you in the eye and tell you that I'm not no criminal. I'm not a criminal.
12 convictions is a criminal, sir. You've got the wrong definition.
Deal with this stuff. I wish I knew the law just a little bit better, and I'm going to make sure I learn that law.
That's not the problem with you. It's following the law. It's your problem.
Hey, that's very much wrong. I mean,
I know. That's the problem with this. And people get assaulted. Police get bitten. And your statement is, I'm not doing anything
I hit
wrong.
the girl 5 times. It would look like I hit her 5 times. First of all, I didn't hit her not 1 time.
Anything else?
Just these. Okay, if you're going to, I mean, can you give me more probation or something? But I don't want to. Look, it's your court.
Anything else?
You want to do anyway. But at the same time,
No. This is a product of your actions, not mine, sir. You have proven to be not only a criminal. Now 12 convictions. 12 convictions when you tried to sell it with just 2, but you're committing violent offenses. You're committing assaults. You're dangerous. And you get caught telling lies. Your way of dealing with it is to try to lie your way out of it.
I don't have to lie.
No, you don't. And that's the incredible thing about it. You do it anyway.
I didn't lie not 1 time.
You just said, I'm sorry, didn't you say I had 2 convictions? Didn't you say I had 2 convictions?
I only wanted to get out of jail.
Didn't you say that I wasn't guilty of biting these officers when we showed under oath you stated you were guilty?
I apologize to you for that. Can you please have mercy on me?
If I'm going to be fair with you.
You don't mind?
You didn't show mercy on the police. You didn't show mercy to this lady.
I promise to follow with all my stipulations on probation.
All
I
right.
promise to get started my payments. I promise to do everything that I need.
You made those promises. I'm sorry. You made those promises when you were placed on probation that you didn't follow. So
I was homeless, Judge Stevens. I didn't even have nowhere to go when I got out of jail. My mom was getting ready to die. She died, actually. She filed lawsuits and stuff that I'm dealing with right now. That's why I did the labor report. Look, I was going through a bad state at the time when my probation officers was telling me to report. I had just lost my mom. She was in the nursing home, first dying.
we have thousands of people on probation. 92% are successful. They have the same issues, sir, and they are able to take care of their business like they are responsible. And you just can't help but interrupt me, can you? You interrupt. That's what you do. You don't follow the rules of decorum. You don't follow the rules of law. You have it your way on your terms, and everybody else suffers. There is sufficient evidence supporting these First Amendment motions to invoke unadjudicated probation in each of these cases, to grant them by a preponderance of the evidence or greater in cause numbers 35195 and 35435. As allegations 1, 2, 3, 4, and 6 have been proven true by a preponderance of the evidence or greater, and the court finds there is evidence on allegation 1, the lesser included offense of assault is proven beyond a reasonable doubt to support these motions to revoke probation. They are granted. And your deferred or unadjudicated probations are revoked in each of these cases. In each of these cases, you pleaded guilty to assaults on a peace officer, something you attempted a little while ago to try to deny until we showed you that you had sworn under oath admitting to this. You pleaded guilty to those cases voluntarily. You were mentally competent to do so. You understood in the and appreciated the consequences of pleading guilty. There was sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted in each of those cases, your sworn instruments, sworn documents admitting culpability in those crimes. That is enough to find you guilty beyond a reasonable doubt, and I now find you guilty beyond a reasonable doubt of those 2 second-degree felonies, which puts you into a position of no less than 2 nor more than 20 years confinement in prison. I find you guilty beyond a reasonable doubt as your probations are revoked and you are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 8 years. And those 2 sentences shall run concurrently. All right. Anything else? Anything else from the defense? All right. We are in recess.
Ah, that was so fun. I had to go through all that. But I enjoyed it. I was so torn because the hearing before that sets it all up so you can hear all his BS. But they call several witnesses. They get really into technical legal arguments, and it was boring as hell. So ultimately, I cut it out and just went to the closings. Trust me, I did you a favor. I even knew the closings would be dry, so I had to spice it up, courtesy of Alyssa, with a dopey skateboard guy. Wherein a fully grown man asks the judge if they can accommodate a skateboard for the next court appearance. Oh my God. That's almost more offensive than this guy. It really is. All right. Good stuff. I got to scoot. Thanks for coming out. I appreciate it. Behave yourselves. As you know, I am not bailing you out. I can't. I'm too far away. But if I could, I wouldn't anyway.